Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. I am your host on civil law, a licensed attorney in both Texas and Virginia. It is June the 5th of 2023, and we are here with your legal news roundup. All the legal news occurring in your world so that you can be better legally informed. Our story today takes us to Tennessee, where a Tennessee law that proposed to regulate and ban, in some instances, drag and cabaret performance has been struck down as too broad and too vague. So, this is an issue that many jurisdictions are looking at, of course, when it comes to these issues, particularly as it relates to school children, as it relates to areas of the public where children might be present, but also some states, of course, have gone further than that in their proposals or in their laws and are stretching into First Amendment protected domains. So Tennessee's law has been at least temporarily struck down for being too broad and too vague. So let's learn a little bit more about Tennessee's efforts in this domain and what the judge thinks about this issue. Let's get started with this. The United States District Judge, who was appointed by Donald Trump, writes that the law is unconstitutionally vague and overbroad, which would encourage discriminatory enforcement. So, some of that, of course, is a problem. Now, when we get into the idea of unconstitutionally vague, when we're talking about a criminal law, we need to make sure that the law is at least understandable. And not every law needs to be incredibly strictly defined, but we need to know what's going on. So there's a difference between vague, which every law might be to at least some degree, because otherwise we wouldn't need lawyers to figure out where the boundaries are. But there's a difference between vague and unconstitutionally vague, where we don't really have an idea of what's going on. So the law itself, he says, is unclear in terms of what it does or does not ban. So that's a problem. He then also says it's overbroad. It covers too much stuff, which maybe that's a problem, particularly when it comes to the First Amendment domain. We have to be concerned about regulating speech as it relates to these issues. There are, of course, lawful regulations of First Amendment speech, time, place, manner being perhaps most notable. But when it comes to a subject matter or viewpoint matter discrimination, we sometimes elevate those standards depending on exactly what we're talking about. And then the idea of discriminatory enforcement, that this would be unequally applied. So some of those are some of the issues that are highlighted by this judge. The judge writing, there is no question that obscenity is not protected by the First Amendment, but there's a difference between material that's obscene in the vernacular and material that's obscene in law. Yes, when we're talking about obscenity and we're talking about that level, we're talking about the Miller test, which is a old test that basically looks to whether or not it appeals to the prurient interest, which is actually a legal term in that case, among other factors, and also is devoid of scientific, artistic, or literary merit. So finding something to be legally obscene is actually quite difficult. And just because it appeals to the salacious doesn't necessarily make it legally obscene. There is, of course, a difference to be had there. And courts, at least increasingly, seem to be very, very reluctant to find things to be legally obscene. So it's pretty hard to trigger that as law has developed. The judge writes that simply to it, no majority of the Supreme Court has held that sexually explicit but not obscene speech receives less protection than political, artistic, or scientific speech. Well, that's not exactly true. The relevant law does regulate speech as it relates to the salacious. The most obvious example being adult clubs or stores which sell adult items. We all know exactly what we're talking about, right? So, can we regulate those kinds of businesses? Yes, we can. Can we ban them outright? No, the law doesn't support that. But we can regulate where they can be in town. We can do zoning regulations as it relates to them. And we can make sure that they're not too close to schools or parks or other things like that. That's fine. We can regulate their hours of operation. We can regulate who is allowed into the establishment. So you have to be, for example, 18 or 21 or something like that. Those kinds of laws tend to be upheld. And we can also regulate what else goes on in the business in terms of what kind of material is allowed. Some states allow, for example, people to be fully in their birthday suit. Some states regulate what sort of clothing is the minimum when it comes to such places. And those kinds of regulations tend to be upheld. And also, of course, they would extend into other domains, right? What you can do in this club in terms of that is not what you can do just in public in general. So it's not quite accurate to say that the law doesn't support regulating the speech which appeals to the salacious but is not legally obscene. That is not quite correct. So the judge, I think, is mistaken on that domain. The relevant law would have banned adult cabaret performances from public property or anywhere minors might be present, which that sounds roughly okay, depending on how we're doing exactly the domain. So public property, we're thinking property owned by the government. That's probably fine because the government gets to control its own property, sort of the same way any landowner is. It's not quite perfect because public property is open to the public, but because it's the government's property, they do have the ability to regulate things like in sort of attire and dress and things like that because it's their property. So they have similar, although lesser rights to a private owner of private property. So to the extent it's oh Lord. To the extent it's their own property, they do have the ability to regulate this, at least to some domain. And also where minors might be present. Again, when we're talking about these kinds of adult businesses where minors might be present, where minors might be present is something that the government probably has the ability to regulate. People who break the law could be charged with a misdemeanor or felony for repeated offenses. The judge used the example of a female performer wearing an Elvis Presley costume and mimicking the musician, who could be at risk under the law because they might be considered a male impersonator. So, okay, perhaps so. That might be a problem, but that sounds a little bit more like an as applied challenge than a facial challenge. So the judge striking down the law completely seems a little bit overbroad in sort of a legal determination. A Memphis-based LGBTQ plus theater company filed a complaint in March saying the law would negatively impact them because they produce drag-centric performances, comedy sketches, and plays with no age restrictions, which might, to some degree, be the problem when it comes to these businesses. Again, how we define such things is problematic. In sort of what is salacious or what is pornographic, there's always the old quote of, I can't define it, but I know it when I see it. So maybe that's true. And maybe we do have some idea what we're talking about. So maybe this is an issue of someone doth protesting a little bit too much. But this judge thinks that the law perhaps could be written a little bit cleaner. So perhaps. The theater company is saying this is a win that represents triumph over hate. Is that the issue? Hate? Or is it the issue that we're dealing with sexualized contact as it relates to minors, which governments have long had the ability to regulate in sort of what is permitted and what is not permitted when it comes to minors in sort of this domain. So there's not exactly, this isn't exactly new when it comes to minors, perhaps a slightly new context, perhaps it's broader, but the underlying idea is something we've been dealing with for a long time. The group says that similar to countless battles between LGBTQ community, our collective success relies on everyone speaking out and taking a stand against bigotry. Yes, when all else fails, just to claim your opponents are homophobic or bigots that helps to really shut down any sort of nuanced consideration or debate. It must be that they're bigots. It must be that they're homophobic. Or maybe it's that they're a little bit concerned about the sexualized conduct when it comes to minors, which is not exactly a new concern for the American experience. Other countries in the world less concerned about this. America perhaps a little bit more concerned about a little bit more Puritan in this domain than a lot of other countries, which don't seem to mind as much when it comes to sexualized conduct in the minors. Well, America perhaps a little bit more Puritan in this domain, but that's our experience for whatever value it has. So perhaps other countries in the world, not so much. But America, yeah, this is something we've dealt with for a long time. This is not exactly new. The state's Senate Majority Leader said they were disappointed in the ruling, saying, quote, sadly, this ruling is a victory for those who support exposing children to the entertainment which is of a salacious nature. Adding that they hope the state's attorney general will appeal the perplexing ruling. Yeah, I think that there will be appeals on this issue for sure as we try to define some of these issues a little bit more clearly as it relates to law. The Tennessee Republican dominated legislature advanced the law last year. Apologize. The Tennessee Republican dominated legislature advanced the law earlier this year, with several GOP members pointing to the performances in hometowns as reason why it was necessary to restrict the performances from taking place in public or where children could view them, which that sounds generally legal. And we could look to the details, obviously, right? Because the devil is always in the detail. But the general idea seems legal. Maybe Tennessee's specific implementation was a bit problematic, but the general idea is something that's been long upheld by courts in every jurisdiction in the United States. Obviously, again, the details matter. Just because it appeals to salacious doesn't necessarily give the government the ability to just regulate it any way they want. The details when it comes to law, as always, are important, but the generalized idea is something that is not new. The word drag itself doesn't appear in the statute. Instead, lawmakers changed the state definition of an adult cabaret to mean adult oriented performances that are harmful to minors. Yeah, that's a little bit problematic. We could probably do a little bit better than that. Furthermore, male or female impersonators were classified as a form of adult cabaret akin to people who take off their clothes. Which is that legal? Is that not legal? Are we stretching too far? Are we, as we approach, this is a bit of a continuum when it comes to these issues. As we approach the obscene, right? The obscene is the ultimate boundary line. When we hit the obscene, the state can just ban it completely. Right? When we hit the true obscene, that is not protected by the First Amendment. So obscenity is the outer marker, right? If you hit this line or go past it, you can just ban it outright. As we approach the obscene, however, the state's ability to regulate it in a way that's not a complete ban gets more and more protected because we're getting closer and closer to the line, right? So the state's interest in regulating the content becomes more and more pronounced as we get closer and closer to the obscene. So one might ask the question, where are we on this continuum? And are we sweeping in too much conduct by this? But that is in the details of the law and how the regulations are put in place. The governor quickly signed off the statute and was set to take place April 1st. However, the date has never been enforced because the federal judge sided with the group and temporarily enjoined the law from going into effect because the judge feels it's overbroad, which perhaps it is. Because again, when it comes to First Amendment protected speech, we have to be very careful in how we are regulating this and how we're writing laws around this. Because if we're sweeping in speech that is more protected than the regulations that we're putting in place, we have a First Amendment problem. It's something that has to be done extremely carefully to keep in place with the relevant law and case law that is developed. The drag law that's in place now represents the second major proposal that has targeted the LGBTQ plus people that has been passed by Tennessee. The all the governor has signed into law a GOP-backed legislation, which has also banned most care relating to children because the puberty blockers and surgeries and all the rest of it. And that, of course, is being challenged in court as well. Although that is less susceptible to challenge because obviously, when it comes to medicine, we don't have the same First Amendment concern because it's not speech, right? It's medicine, and states' ability to regulate medical practice is typically more protectable by the state in sort of what the state can and cannot do because the states has long had the ability to regulate medicine. So those cases also being challenged, but not subject to the same considerations when it comes to the drag shows because of obvious First Amendment considerations that only apply in the drag show related domains. Thus, that brings us to the end of the story for the moment about the Tennessee anti-drag law, which one judge has looked at and put in place a temporary injunction. I'm not sure I fully agree with the judge's reasoning on this case, and the judge's statement that the law doesn't appear to support regulation other than the obscene does not, to my mind, appear to be a true statement of law. Obscenity would allow the state to ban it outright. That much is clear. But the relevant law when it comes to adult shows, adult theaters, adult stores, in terms of regulation, it does seem to be the truth that the state has the ability to regulate where, when, and how, including by banning minors. And to the extent this is occurring in the open and in the public, obviously the state would seem to have a broader interest. And to the extent it's happening on governmental property, even a broader interest still. So it doesn't appear to be true that the state doesn't have the ability to regulate this or even prohibit it in certain places or at certain times, given the relevant law. So I'm not sure I agree with the judge's reasoning, but that will have to be teased out in the details where everything, of course, comes to a more interesting domain. And this will also be, of course, challenged and appeal. And regardless of what the courts relating to this particular law do, this exact issue will, of course, continue to percolate up in other jurisdictions, in other courts, and in other circuits, leading, I'm sure, to an inevitable circuit conflict that one day the Supreme Court will have to resolve at least one way or another. But for the moment, that brings us to the end of discussion of this case. Push the button. Yeah. Okay, good morning, everyone, and welcome to a slightly tired, slightly off his game, uncivil law, where uncivil law apparently is choking on nothing in particular and still desperately trying to wake up as he hopes the caffeine will eventually kick in. Good morning to everyone. And also, apologies to everyone for being late today. I had trouble falling asleep last night, and apparently, the medication I helped to take to get me to sleep kept me out a little bit longer than I desired, and also is now fighting the caffeine for supremacy in my body. So that's all working super, super great. All right. Oh, Lord. Blah. All right. Good morning, everyone. We're alive. Mm. All right. I had my showcase last night for me as an improv student, something I've done before, at least in DC. It's been a while, but I did my first public performance as an improv actor in a while. So we had finished level 2 as improv students 2 weeks ago, 3 weeks ago, I guess today. We finished level 2 3 weeks ago, and at the end of level 2 we do our first public performance, and that happened last night, and it went very, very well. So that was really plus. So we had a lot of fun last night, and that was a good time. Fantastic. All right, let's read another thing. I'm sorry to hear about your friend, Kestrel. I'm very sorry to hear about your friend. And I'm sorry to hear that they died of cancer, which also took our secret mixed squirrel. Oh, Lord. Turning our attention to the issue of transgender rights when it comes to the battle between the states and the federal government, the federal government has filed a lawsuit alleging that Tennessee's programs discriminate when it comes to transgender people. This is partially an issue the Supreme Court, of course, has also resolved as well when it came to the issue of transgender rights in the workplace. The case of Bostock, in which Justice Gorsuch wrote an opinion, which I thought was quite brilliant, dealing with the issue of how sex relates to sex discrimination when it comes to the Civil Rights Act, and noting that the Civil Rights Act prohibits discrimination on the basis of sex, and then noting that transgender to some degree might be viewed as discrimination on the basis of sex. And it was a really interesting legal opinion when it came to originalist thinking, when it came to Justice Gorsuch writing for a more textualist approach, and Justice Kavanaugh, for example, writing for what might be considered a more whole rounded originalist approach. So perhaps exposing a difference between textualism and originalism that I hadn't really conceived of before. So it was a really, really interesting case for that reason, because it further delineated my own thinking. And I was like, I think Justice Gorsuch is actually right on this issue. So more a textualist myself than an originalist. I didn't even know there was a difference between before Gorsuch, and he clarified that. Well, anyway, some of that issue is still percolating, and the federal government has filed a lawsuit dealing with how Tennessee gives employee benefits relating to this. So let's learn a little bit more about this issue. A federal lawsuit recently filed between, no, A federal lawsuit recently filed by two people alleges the great state of Tennessee and its insurance committee are discriminating against transgender people is relations to an employee benefits program. The plaintiffs are a 30-year-old transgender woman who is an academic advisor at the University of Tennessee, and a different transgender woman who is a former special education teacher at a board of education. Both plaintiffs suffer from gender dysphoria, which is psychological distress as a result of a disconnect between a person's assigned birth and a person's perceived gender identity. The relevant physicians deemed it medically necessary for them to receive surgeries to treat their transgender dysphoria. However, the relevant plaintiffs are enrolled and were previously enrolled, as the case may be, because one of them left their job in the state of Tennessee's comprehensive medical and hospitalization program, which denies cover of surgery or treatment for or related to a sex transformation. This only bars coverage for transgender people, according to the complaint. Okay, so we understand the issue. We've got two people who are state employees. They work for the state in various forms. You know, maybe it's local, maybe it's county, maybe it's state proper, but either way, it doesn't really matter because we've discussed this before when it comes to the issue of state level supremacy. unlike the relationship between the federal government and the state government, where we deal with this idea of federalism, where both the state and federal governments are simultaneously sovereign. And so we run into this issue where the one can't necessarily control the other as it relates to various things. That sort of concept does not apply when it comes to states versus, for example, cities, counties, towns, or anything else. Obviously, what a state chooses to do as a matter of its own state law or its own state constitution is the state's choice. But it's the state's choice. So states can, and to some degree do, restrict themselves when it comes to these issues. But some states don't. And even where they choose to, they can choose to not do to. So states, when it comes to cities, counties, towns, and all the rest of it, are ultimately God. They can do whatever they want. There is no countervailing balance. It is up to the state's whim and mercy as to whether or not cities exist. And if they don't want them to exist, they don't have to, because that's how much control they have. So anyways, we have this Tennessee Comprehensive Medical Program, which apparently binds everyone as it relates to any kind of state work in Tennessee. Fine, no problem. We can do that. Then we say we're not going to give treatments for the sex transformations. Okay, can we do that? Well, it only applies to transgender people, but is that the same thing as discriminating against transgenderism? Because, well, we're not providing it to anybody, right? We're not providing surgeries to anybody. So if we're doing it equally to everyone, maybe that's not as much a problem where it was, for example, in Bostock, where we were treating different people differently based on sex. So not clear that that falls in this domain, but then, of course, that is the legal issue. And then, of course, there is federal law as it relates to this, and the federal government is, of course, pushing in this domain. So even if Bostock doesn't go that far, which I don't think it does, the federal government would like to push the law further when it relates to the Civil Rights Act, and would like to have more things covered by the Civil Rights Act than the federal courts currently recognize. So even if the law doesn't currently allow for this, they'd like to push the law in that direction, or at least that seems to be true based on their lawsuits. So all that stuff is what's happening. The plaintiffs in this case have contended that they asked the state to remove the exclusion, but the state has said, no, we're not going to do that. By denying coverage, the defendants are arguing, by denying coverage, the plaintiffs say that the state of Tennessee is in violation of the Equal Protection Clause of the 14th Amendment. Probably not. Title IX of the Education Amendment. Probably not. Title VII of the Civil Rights Act. That one is at least closer. They are asking for a trial by jury. So no, probably not on the 14th Amendment. Probably not on the Title IX. Title VII is more of your go-to, right? Prohibiting discrimination on the basis of sex in the workplace. Is this discrimination on the basis of sex in the workplace? Is it discrimination as it relates to a benefit relating to sex? Because discrimination, when it comes to sex, not only applies to the employment itself, but any benefit or any sort of advantage or any sort of asset of any variety that comes as a result of employment. So the health care would qualify as sort of a benefit, right, that comes along with employment. So yes, it is ancillary, but would be protected by Title VII. But the question is, does Title VII cover this kind of thing? Does it require the state to offer transgender surgeries? They offer other kinds of surgeries, but they don't offer certain kinds of surgeries that are sex related. Is that discrimination on the basis of sex? That's what the federal government's trying to argue. One of the plaintiffs received hormone replacement therapy. As a result, her providers contend that that treatment wasn't enough to solve the problem. So they need the gender transition surgery. So the government did offer them hormone therapy, but wouldn't do the surgeries. So we tried that and we found it wasn't enough. We need more. The coverage, of course, was denied, and the person can't pay for the surgery themselves, which, regardless of whether they could or couldn't pay for the surgery themselves, would not solve the issue. Even if they had enough money to pay for it out of pocket, if they're entitled to it as a benefit, they're entitled to it as a benefit. So their own ability to pay is irrelevant because it's a government offered benefit in relation to work. And so if they're entitled to it, they're entitled to it. So let's figure that out. Because of their inability to access the medical treatment they want, the person feels that their life is on hold. The unmet healthcare needs continue to weigh on their, leaving them feel stressed, anxious, depressed, and preoccupied. So they say that they're suffering mentally as a result of not getting these treatments. And they feel the treatments would help them mentally. The efficacy of that when it comes to treatments in relation to mental health in this particular domain is also somewhat questionable in this. But her own doctors, wherever they found them, she's able to find doctors that say it's medically necessary. So, okay. But just then, just because a doctor says it's medically necessary doesn't require the state to recognize it, because states have long had the ability to regulate medical care. And states do prohibit certain medical treatments and for a whole bunch of bases. So you can find a doctor who will approve of just about anything. It doesn't mean the state has to recognize it. The other plaintiff in this case says they fear for their life because of masculine facial features and increased scrutiny on and violence toward people who are visibly transgender, especially transgender women, and feels unsafe in public. Every time she leaves the house, she braces herself for violent attack, which, okay, I'm not really sure that that leads to a legally cognizable interest in a surgery. Just because I feel like I might be subject to attack doesn't necessarily require the state to do anything about it because of no affirmative duty. So, the government doesn't generally have a duty to keep you safe. So if you feel like you're particularly vulnerable, well, you could tend to yourself, especially in Tennessee, where I'd like to point out that the laws relating to gun carry are not as tight as some jurisdictions. So get yourself a handgun or pepper spray or taser or something, and you can help protect yourself that way. That would be good. So talk to Pink Pistols. They can give you some interesting insights when it comes to the LGBTQ and the gun rights and gun training, because that's one of the things they do with their time. The plaintiff said in their complaint that the plaintiff continues to experience severe gender dysphoria from their facial features. The face is the first thing she looks at when she looks at in the mirror, and the first thing that other people see when they look at the person, which, okay, maybe that's true. That people look at the face first, although maybe not. Depends on how people's observations go and sort of what body feature they serve force look at, but they think the face is the thing. Okay. Thus, that brings us to the end of the Thus, that brings us to the end for the moment of the law dealing with transgender rights as it relates to surgery, as it relates to a government provided healthcare plan for government workers. The government employs people. One of the things it offers is a healthcare plan. Federal law prohibits discrimination on the basis of sex in employment or conditions or benefits relating to employment. And so that this government provide healthcare plan, which is part of the thing that they get as being an employee, would be bound by the federal law. So the question is, in denying this surgery, are they discriminating on the basis of sex? And are countervailing considerations, like the fact that medicine is typically regulated by the state level authority, enough? Because maybe the federal law doesn't clearly erode state authority in this domain. So one of the relevant questions when it comes to this will be the issue of, did the federal government attempt to, or was it clear in co-opting authority when it came to medicine, which is typically a state level concern? And also, even if they did, is this discrimination on the basis of sex? Many interesting issues to be resolved in that domain for sure. That, for the moment, brings us to the end of discussion of this case. Okay. For the 169 of you who are currently here, as I struggle this morning, I appreciate it. You are the rock stars as I struggle to keep it all going. But as they say, the show must go on. So where we can, we do. Push the button. Yeah. All right. I want some Mexican food. I want sleep and Mexican food. All right. Okay. Am I on drugs? No, I am not. I'm just not at my best today. I'm sorry you missed it earlier. I didn't sleep well last night, and the caffeine I'm taking is fighting me. So I'm not at my best today. I guess caffeine is technically a drug, so yes. Is caffeine a drug? That's a good question. Okay. I don't have the time to deal with that right now on whether or not caffeine qualifies as a drug or not. All right. So Mucinex sounds good right about now. Okay. In Texas news, my home state, of which I am a citizen of the great state of Texas, proud to be a Texan citizen as well, the largest teacher preparation program has suffered a blow in relation to a court ruling. So we'd like to have teachers. Teachers are a good thing to have. And we want to have a program to get the teachers and teach the teachers and accredit the teachers. All those things are great, but the way that we're going about it has left to problems and has led to such a problem that the entire program itself is, at least for the moment, in some jeopardy. Let's go ahead and get started with this. Ugh. The future. My throat. Oh my God. It was like, what was it like? Thursday or something? Or Friday? Where I like felt like I'd like tore my vocal cords, stretched them. And now I'm having that same sensation again where when I project my voice, I'm having that same sensation where I tore my vocal cord or stretched it in some way. All right, let's continue on. All right. Mm. The future of an embattled teacher preparation company. No, let's try not to have my voice crack while I'm doing that either. That'd be great. Maybe I'll get some pancakes. Nah, that's too many carbs. The future of an embattled teacher preparation company, which enrolls more educator candidates than any other program in Texas, remains in limbo after Travis County judge, that's Austin, threw a curveball in the plans. The Teachers of Tomorrow, also known as A plus Texas Teachers, is under scrutiny after failing to provide state education officials that they had corrected a long-standing operational problem. So there is an issue that is known with this educational program. This particular company enrolls more educators than any other program in Texas. So not the only one, to be sure, but it is the most dominant one in the state, which makes sense, of course, Austin being the state capital, and that they would teach a lot of teachers is not, of course, particularly surprising. And they have a bit of a market hold on Travis County. And there is a problem because there has been a long-standing operational problem. The Texas Educational Agency recommended last year revoking the company's accreditation, citing failure to meet the conditions of the improvement plan that they had. So they were already on probation and had a plan to try to improve things, and things didn't go well. They weren't able to meet their goals. So now their accreditation is threatened. If the accreditation is in fact yanked, the company, of course, would not be able to produce certified teachers. So this has been a long-standing problem for this particular company. Haven't been able to get its act together, now in danger of losing its accreditation. And the single biggest source of teachers might be lost, but maybe the teachers they're producing aren't doing a really great job, so maybe it's okay. Before state officials can vote on the company's future, both sides would have to present arguments before an administrative judge, and that step for the moment is currently stalled as they try to fight the lack of accreditation. The Travis County judge has ruled in May in favor of the program, granting a temporary injunction. The decision stops the educational officials from moving forward for their case, at least for the moment. So this is an administrative process, right? In terms of how teachers get accredited and how the people who accredit them get accredited, right? The accreditation of the accreditors. And this is a program that's run by the Department of Education, as you would reasonably expect. But a district judge says that for the moment this is stalled. So we've moved out of the administrative and into the legal, at least for the moment, on all that stuff. The Texas education spokesman said the officials can't comment on the litigation, but the state does plan to appeal, which makes logical sense because the state isn't able to run its accreditation process in a way that seems to be in accord with what they're trying to do in terms of this school is not doing things the way we want to. Teachers of Tomorrow, for their point, said they're pleased with the judge's ruling. I bet they are, saying the Teachers of Tomorrow has maintained the highest level of regulatory compliance, cooperation, and adherence to the process for contesting the review's findings. Uh-huh. Yeah, I'm sure you're maintaining the highest level of compliance. That's why you're in this boat. You know, it could be that the county is acting completely arbitrary over here, but it is Travis County. And I wouldn't imagine that they go after teachers just for the hell of it, because Travis County is at least in Texas level, left leaning. It is sometimes called the San Francisco of Texas, which I'm not sure that's completely fair, but well, it is probably the most left leaning place in Texas. So one would think they wouldn't just go after teachers for the hell of it. So the fact that they say, "Oh, we're maintaining the highest level of regulatory compliance," I have my doubts. If Travis County is acting against you in this particular domain, I'd imagine it's because things are not going well in your company. That would be my inferences about the relevant thing. Company leaders, for their part, have argued the state unlawfully held them to invented, invalid, and inapplicable standards. Ooh, rule of threes and alliteration. Well, la di da di da. Invented, invalid, inapplicable. Wow, I love it. Yep, you got your rule of threes, you got your alliteration. Someone went to a public speaking class. The company's entire business is at stake should the state bring the case to the State Office of Administrative Hearings. Yes, that would be true. Yes, your entire company might lose its accreditation status. You have correctly understood the nature of the problem. The fight for the issue comes as states no. The fight relating to accreditation comes as the schools themselves face an ongoing education shortage, which is a problem that many states have had. Difficult to find enough teachers. You could try paying them more, of course. That might help in acquiring better quality content, but of course, well, you don't want to do that. And also, education is already way too expensive, mostly because there's too much bureaucracy and too much oversight and stuff like that. But we weren't worried about the more systemic problems. We just noticed that it's hard finding teachers. And if we shut down the program that gets us the most teachers in the state, well, obviously we won't have those teachers anymore. So that would further the need to get further the problem of getting teachers. But then again, what are the quality of teachers we're getting? So if the quality of teachers we're getting isn't good enough, maybe it doesn't matter. The relevant program prevents people with an alternative pathway to the classroom, which helps people who didn't even necessarily go to college with becoming teachers. Okay. No, let's try that again. The relevant program that we're talking about helps prevent, no. The relevant program helps people who went to college without intent to become teachers to become teachers. So, of course, some people go to college with the idea of becoming teachers in mind and get an educational degree to help with education. But, not everyone who goes to college for that reason, but they might want to teach anyway. And because, they might be very good teachers, notwithstanding the fact they don't have an education degree. In fact, they might even be better teachers than people who didn't get an education degree, at least in my humble estimation. So this program helps people with college degrees but not in education become teachers, which sounds like that might be a very good thing. The company recruits many people in search of a second career and trains them in how to become teachers through online coursework. But state auditors repeatedly found the company fell short of standards. It misled potential teachers with its advertising, did not support candidates with required mentors, and failed to demonstrate its training was based on research. So maybe a good goal, maybe we're going about it in a bit of a haphazard way. So things are not always great. The company was also subject to an excessive number of complaints from teacher candidates, some of whom left the profession in frustration. So maybe our company is acting a little bit maliciously or at least incompetently, deceiving people through its ad, inducing them as be like, you can become a teacher too. It's so easy. And then when we actually get into it, less so. And people are leaving the program. So state officials can't help noticing you're getting a lot of complaints. So maybe it's because you're not doing a very good job as a company. Thought for concern to be sure. After a scathing audit in 2021, the State Board of Education placed the company on probation, then appointed a monitor to help analyze operations and ensure the company hit benchmarks. But after several months, the monitor that was appointed found not so much. So we got enough concern that we appointed a guy to oversee your operations, to give you that looking at you concern, and not so much. For example, the staff identified 350 candidates that went through the program and saw evidence that they had sufficient field-based experience. But the company only provided evidence for 80% of the candidates, and we needed to hit 90%. So we needed to get an A, and we got a C plus. So not great. So we need to have evidence that our teachers are qualified, and we weren't able to do that. So going great. The staff The staff noted the company did not provide that all candidates spent enough hours observing the classroom as part of training. And while the company determined, and while the Board of Education determined the company provide evidence to the vast majority, the 79%, they didn't provide enough evidence as to 90%. So yeah, we got a majority, we got 79%, but we needed to actually prove that 90% of our teachers were qualified. And no. The company was subject to 19 formal complaints last year, more than all other programs. So that's how many complaints we got. We got more complaints than every other program. So going great. The complaints relate to processing issues, non-responsiveness, and lack of support. Teachers of tomorrow over here who would, no. Teachers of tomorrow over here, who would very much like to continue operating their for-profit business, said that the analysis includes fundamental errors. The company hired its own consultant to conduct a review, which found the program was compliant. Wow, amazing. The experts we hired for our company say we're doing a great job. What are the odds? The company we hired to audit us said we're doing great. So we disagree with the state level audit. Since the auditing problem, new leadership has also taken over, and they say they've invested $6 million to update the program. So we're trying to fix the problem. We're spending money. Okay. Leaders say they remain committed to working with state officials to combat the teacher shortage crisis and to adhere to the rigorous standard, but not going great. The final decision, of course, would ultimately lie with the State Board for Education Certificates, which is, of course, what you would expect. For now, the company remains on probation, and potential educators can continue moving through the program for the moment while all this is being sorted out. Thus, that brings our attention. No. Thus, that ends our article relating to the Texas education program, which infects this one particular company, which is the most dominant company in Texas when it comes to the education. But they've received 19 complaints, more than any other competitor in this domain. And also, they were audited by the state and found to be deficient. But it's okay. Their own auditors that they hired say they're doing a great job. And I'm sure we can take it at face value, I'm sure. But this issue is proceeding with also the courts getting involved, putting an injunction on the whole thing for a moment. So unclear how this will resolve for the moment. And that for the moment brings us under attention of this story. Push the button. Yeah. Okay. Where are we in this thing? All right. Let's see. All right. So let's do this, this, and Florida Man. All right. I think we'll do three more stories. We'll do two more stories and then Florida Man. Every now and then I fell apart, and I need you more tonight, and I need you more than ever. Okay. All right. Yeah. In disability accommodation news, a lawsuit that alleges a state agency failed to accommodate a disability was tossed in relation to a narcolepsy diagnosis. So, one of the issues that you have when it comes to public accommodation and the government as well is that you have to accommodate people for disabilities. But the law only requires you to give a reasonable accommodation. And then you get into the question of what is a reasonable accommodation. Well, this person had a narcolepsy diagnosis. They said the agency failed to accommodate them, but the court tossed the case. So let's learn a little bit more about the issue and the court's reasoning. Let's get started with this. A Minnesota agency has prevailed in a failure to accommodate and retaliation suit brought by the employer with a narcolepsy diagnosis. In the relevant case, the U.S. District Court threw out the claim from the employee. The person who was employed as a teacher within the Minnesota offender program for those people with the offense relating to the salacious. They struggled with fatigue for many years, and in 2015 was diagnosed with narcolepsy. Each night, they require about 16 hours of sleep. That is a lot of sleep. So if you're working 8 hours a day and sleeping every other hour, well, that doesn't leave a lot of time for everything else. So it's all that stuff. While the job performance itself was not affected by narcolepsy, it did cause them to arrive late for work. So the argument, at least, was well, I'm performing fine, but I'm a little bit tardy sometimes because, I was asleep. However, when they arrived late, they would make up the time by flexing. That is, they make up what they missed at the beginning with a later shift in the day. This shift in time apparently was not an issue with the supervisor. So we show up a little bit late sometimes, but we add time to the end of our day and we flex. So, this is obviously an issue of employment and some details. Some jobs it matters that you're there from hour one, hour certain to hour certain. So some jobs it really matters when you show up. Some days maybe it doesn't show up as much. It doesn't matter as much. And you can flex. And at least in this case, the supervisor says, okay, fine. You're late, but you add time at the end of the day. So you're putting in a full day. Your performance is fine. I'm happy. Okay, so that's what's going on. The doctor recommended working 4 10-hour shifts instead of 5 8.5-hour shifts, allowing them to get more sleep. So the doctor says, okay, if you if you do shifts 4 days a week, maybe it will help you get more sleep. So try that. Okay. They asked for the accommodation, but that particular accommodation was denied. So how about I work 4 days a week instead of 5? But they said, no, we're not willing to accommodate you that way. So they filed a complaint with the Equal Opportunity Commission in 2017, alleging that the employer had not accommodated the disability. However, they did approve the accommodation a couple of months later. So they said, look, I want to work 4 days a week instead of 5. They say no. We sued, and eventually they changed their mind. Like, fine, we'll do 4 days a week if that's what you want. Everyone is happy. All right, fine. Following the modification, the employee says that their employer's attitude began to change. So they may have accommodated you, but perhaps they're not really happy about it. While the employer previously approved requests to attend professional development training, those claims were denied after the modification. So we see that, yes, you gave me what you wanted, but you're treating me not the same way you did before. You're treating me with a renewed hostility. So we think that you have retaliated against me for asking for accommodation. A couple of years later, the employee requested a 3 months professional development leave to attend summer classes at Minnesota State University, where they were pursuing a PhD. The employer denied the request, citing staffing needs and the impact on client program. We can't have you taking 3 months off because the offenders don't take time off. We need you here. So you can't have 3 months off sabbatical, no. 2 weeks after the request was denied, the employee resigned from the program, and then initiating action alleging failure to accommodate, as well as retaliation. So basically, I was forced to quit. You didn't fire me, because the state firing someone is really, really hard, because people do have a property interest in their job that the courts have held when it comes to the government, because the government is the one giving it to you. So, once you have, basically tenure or the equivalent, which depending on the nature of the job position can vary, but once you are sufficiently long enough, the government's ability to just take your job away, not so much. So they have to show some sort of deficiency. They can't just do it for the hell of it. They have to, like a private employer. A private employer can just basically fire anyone at any time, but the government can't do that. People are entitled to due process because the courts recognize a property interest in the job. So she says, basically, you forced me to quit. You didn't fire me, but you made my life so miserable that it's constructive termination, which is a concept that does exist, incidentally, as it relates to both public and private employers, right? Like, for example, you can't typically get unemployment in relation to a private employer if you quit, as opposed to being fired. But if you can prove that you were essentially forced out of your job, then you might be able to get unemployment. So similar concept, right? Constructive termination. Also, for what it's worth, this also applies to concepts other than employment. For example, in a landlord-tenancy agreement, there's this idea of constructive eviction. Same kind of concept, right? The landlord could bring an eviction proceeding against you and evict you. But what if instead of doing that, what if they do other things that cause you to leave, right? So constructive eviction. So a concept that exists in law. You constructively terminated me. Okay. The employer claims that they were forced to leave the provision, preventing them from retiring, which of course would mean a loss of benefits. They also argued they never received all the accommodations. The defendants moved for summary judgment. The argument alleged that the employer failed to accommodate because although they did grant the request for 4 days a week eventually, they did not accommodate the disability fully, as they did not allow her to flex the time. So before, you allowed me to flex my time. Now you don't let me flex my time. So that was a change in conditions. They also maintained that if they, okay, the employer responded by arguing that they never actually asked to flex as part of the accommodation. So you asked us for the 4 days a week, and we eventually gave it to us. You never asked us formally for the flexing. This whole flexing thing that you were doing before was kind of an informal arrangement, and we decided that we didn't want to allow it. And you could have asked us for that as an accommodation as well, but you never even asked. The employee over here said if they had asked, it would have been denied. So it would have been futile, they say, to ask. Okay. As classes began promptly at 8 a.m., the employer expressed concerns about the ability to prepare for class. So yeah. However, they responded that her doctor mentioned the start time should be between 7:30 and 8:30, the 4 days a week she's worked, which, that's what the employer gave you. They said work starts at 8. Your doctor says work start time should be between 7:30 and 8. We gave you what your doctor said that you needed. The court therefore rejects the argument, saying the doctor mentioned a start time that within a range is not the same as allowing her to arrive anytime within the time frame and allowing her to extend the workday as needed. So the doctor says, I recommend a start time that's between 7:30 and 8:30. The employer says 8 o'clock and says that's not fair because the doctor said 8:30. No, the doctor said 7:30 to 8:30. And we said 8, which is smack dab in the middle, incidentally. We didn't even pick 7:30, which we could have done because it would have been a thing. So the doctor's saying you have to accommodate this employee by saying the start time should be sometime in between this. We picked something smack dab in the middle, and we didn't let you flex. But that's not the same thing, right? 8 o'clock is not the same thing as 8:30. The doctor said up to 8:30, and we said 8, and we want time certain. So yeah, we didn't let you flex, but the doctor said 7:30, 8:30, and we gave you exactly what the doctor said you needed. So yeah. The court also reasoned that the request to flex time was never a part of the accommodation. So granting summary judgment. Sounds about right, guys. I mean, okay, look, this isn't super complicated, right? So the employer had one relationship with you before with the 5 days a week. It's like, yes, we'll let you flex your time. But it was an informal arrangement, right? You want to move from the informal to the formal. Fine, right? You want to move into a formal relationship. Okay, that's cool. So you say, all right, I want 4 days a week. All right, great. What time? The doctor says sometime between 7:30 and 8:30 would be great. All right, how about 8 o'clock? It's right smack dab in the middle. Well, the doctor said 8:30. No, the doctor said 7:30, 8:30, and we picked 8 o'clock. Well, that's not fair. You used to let me flex, but you never asked us for it formally. It was an informal thing. And you wanted to move from the informal to the formal. And you could have asked for it and you didn't. So we can't accommodate that which you never asked for. So yeah, that's not going to go very far. The court okay. Oh yeah, this is an interesting one too. Yeah, Memonex says I'd employer claim I set a precedent by working certain patterns and become contractual through mutual de facto consent. Yeah, that can work as an argument. And that can work as an argument. Um, it is, yeah, that can work in contracts as well, generally speaking. So that is a possibility in contracts, generally speaking. Um, it can be behavior. Courts will frequently look to behavior on a contract as a way of interpreting the contract, especially if the behavior is within the language of the contract, but not necessarily required by the contract. So courts will look at this two ways. So first of all, is the behavior outside the bounds of the contract? In which case we're viewing it as a modification to the contract, right? Modification by behavior. So that's one possibility. The other possibility is that the behavior is within the bounds of the contract, but not exactly required by the contract. So yeah, contract by behavior. So, if just to pick an example off the top of my head, let's suppose that, I have a contract with you and the contract requires you to deliver to me cement every day because that's the nature of my business. You're a company that provides cement. This is what you do. I'm a general contractor. I whatever. So we have a contract that says you must provide me cement every single day. but it doesn't actually specify a time in the contract, which seems like a massive oversight on my part, but whatever. But let's say that, you deliver me concrete every day at 7 a.m. And I never said anything about it. You never said anything about it. We're just operating along happily. You deliver me concrete every day at 7 a.m. And then one day, and then maybe not even one day, maybe then, after some period of time where this is happening, then maybe you start delivering to me at 11. And I'm like, but we agreed on 7. It's like, that's not what the contract says. Right. So the behavior of the parties can often be a way of interpreting the contract where the behavior is consistent enough for long enough, and if it's not modifying the contract. So if it's modifying the contract, like you start delivering me only every other day at 7. So there's a difference between you providing me, cement every other day at 7 versus every day at 11, and sort of how the courts will look at it. So modification, and also you get into issues of waiver because the condition was waived. And a lot of this, of course, can be specified by the contract itself. So you'll often have these problems solved by the contract itself because the contract will say, for example, our acquiescence to something does not constitute a waiver on our part. So, like, just because we let you deliver at 11 a.m., if the contract says 7 and we said 11's fine, we say, oh, that's not a modification. The contract itself can specify that. So that was a little off topic, but yeah, that's possible. That's possible. Behavior on a contract that is long enough, consistent enough, can potentially be a modification on the contract, or at least, if not a modification on the contract, can be a way of understanding the contract. Also, you get into this idea of what is understood within the relevant market. So in terms of understanding a contract, so for example, let's suppose you're a cement company and I'm a general contractor, and let's suppose that I'm a little bit more specific of a general contractor. Let's suppose I'm a general contractor for residential buildings. Okay. And let's suppose further, because I'm making shit up. Let's suppose further that the cement that is for residential buildings is well known and understood in the market. And let's further assume that the residential cement is substantially different than what would be used in a commercial context. Now, maybe this is regulation, but maybe not. All right. So it doesn't really matter either way, although the regulation would actually help further. So you could assume there's a regulatory requirement. You know, concrete that's used in residential building must be X, and concrete that's used in a commercial building must be Y. So if there's a regulation in place, that would further help, but it isn't necessarily required. Let's just assume that there's not even a regulation. Let's just assume that for whatever reason, businesses, when they make concrete for residential buildings, always do X, and when it comes to commercial, always do Y. And why? Who knows? I don't care. They just do, right? But this is understood in the community. This is understood, right? If I'm making the cement for the residential buildings, it's X. If I make it for Y, if for commercial, it's Y. And everyone understands this. Everyone understands this. Is it a regulation? I don't know. Maybe, maybe not. But it's an understanding everyone has, okay? And I am uncivil residential general contractor Inc. Okay. That is what I do. I am a residential contractor. I build residential buildings. That's what I do. I'm really fucking good at it. Right. And I sign a contract with you, my cement supplier, and be like, I need cement. Now, me being a complete idiot, I didn't specify in the contract what kind of cement. I didn't specify for residential buildings because I'm a fucking moron. Okay, I didn't specify any of this because I could have cleared all this right up in the contract, but I didn't do that because I'm a fucking idiot. All right, all I wrote is I want cement. Period. End of statement. Right, and you start supplying me cement that is commercial for commercial buildings instead of residential, and I'm like, that's not fair. I need the cement for the residential. It's like, oh, it doesn't say that, which it doesn't because I'm a fucking moron. Okay, well, fortunately, the court is going to come save my ass, okay, on this situation, because the court's going to be like, okay, well, this is what is understood by cement. The contract doesn't specify it, but in the ordinary course of normal trade, in this particular context, what means is cement that is this. That is what everyone understood. We understand the term to mean this, and bingo bango, the court will come save my ass. So you can have that kind of scenario. And I remember a case that actually was kind of like this, right? There have been cases that are like this because people are fucking morons. I remember a case in law school we studied where it was chickens, and it was some sort of food related thing, and apparently, like, chickens for food, like to be eaten, have to be like a certain kind of chicken because some chickens are not suitable to be eaten. I'm not an expert in chickens. I just remember vaguely the case existed, right? So the contract called for chickens without any specificity because, again, we're a moron and we now have to figure this out in court, right? So it just said, deliver me chickens. And one day the supplier provided chickens that were not food grade chickens. Don't ask me any questions. I don't know any more than I'm telling you. I just know that they weren't suitable to be eaten. Okay? There is apparently a difference, and this difference is understood, and there are the chickens to be eaten and chickens not to be eaten by human beings. And like apparently this is understood in the trade, right? Good chickens for eating, not so much for the chickens for eating. Maybe dog food, but not so much for the human beings. Okay. And the contract, all it called was for chickens without any specificity because he's a fucking moron. All right. And so then, one day the supplier turned up with the, non-food grade chickens. And like, that's not fair. And like the contract says, oh, it's just chickens. And it just says chickens. Any kind of chickens will do. And the court saving the guy's ass said, okay, look, the contract doesn't specify what kind of chicken, but look, this contract is clearly in contemplation of food stuff. This is a food manufacturer for the human beings. And what is understood in this domain is these kinds of chickens, not these kinds of chickens. So this term chickens means this, not this. And you have to supply this because that was an understood term and blah, 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 blah. So these kinds of things have actually happened. All these problems can be solved, by the way, if you just specify it in the contract like a normal person. But if you don't do that, then the courts have to get involved, and this is some of the bullshit we have to do. Because now we have to fix your shit. Yeah. Also, while we're on the subject, as long as we're doing some legal education over here, why not? As long as we're on the subject, if a term has a private understanding between the parties that is mutually understood, that deviates from common understanding, the mutual understanding will also differ. And I don't remember what case this is, but I remember it existed. So maybe it was chickens, maybe it was something else. I forget what it was. Like the contract called for, I don't know. I don't remember what it was. Let's say the contract called for delivery of 100 units of two by fours. Okay. The contract says you will deliver to me 100 two by fours. Okay. That's what the contract actually says. All right. But we, as a matter of our private understanding, okay, we say that, what we mean by two by fours, what we really mean is chickens. I don't know why we're doing, don't ask questions. Okay. I'm just telling you. All right. So the contract says 100 two by fours, but we mutually understand the term two by fours to mean chickens. Okay. So you actually show up with actually 100 two by fours. And I'm like, that's not fair. What I wanted is chickens. And you said, but the contract says 2x4s. If you can prove, and again, this is all a problem, but if you can prove the term 2x4 really meant chicken, the court will enforce the mutual understanding over the word. Because what does the word mean? What does 2x4 mean? Right? And now what it means is chicken. Why did you call it a 2x4 and not chicken? I don't remember. But this case has also happened as well. Not that exact example, but the same idea. Right? The contract calls for delivery of something. But what it really meant was something completely unrelated to that. I don't remember if it was an illegal thing. I don't remember what the issue is. I don't remember why they did it, but they did it, right? They wrote into the contract something completely different from their mutual understanding. But, when it came to trial, we finally found out that, yes, you really did have a mutual understanding. This term really means this completely other thing. What matters is the meeting of the minds, right? What matters is what you really mutually understood, right? Contracts are all about meetings in the mind. And damn it, what your mutual understanding was chickens. You wrote 2x4s, but what you meant was chickens. Deliver the goddamn chickens. So that case has also existed. So these are some of the fun things that we've had when it comes to contracts. And it's like specificity. And again, it bears repeating. All these problems can be solved by just specifying it in the contract. Look, dude, if you want chickens, just write fucking chickens. Just if you want delivery at 7 a.m., just say 7 a.m. If you want residential concrete, just write residential concrete. If you want the food grade chickens for human beings, just write that in the goddamn contract. Just put it in the fucking contract, please, for the love of God. And if you do that, you'll solve all these problems. Moving on. Moving on. Oh, Lord. The court. The court also grants summary judgment for the employer on the retaliation claims. The employee cited her denial of flex time, different approaches to professional development requests, and constructive discharge as examples of adverse actions. However, the court determined that defendants proved legitimate reasons for their actions. Regarding flex time, the court found that it would not have benefited the program for the employee to flex their schedule. As far as training for the time off request for 3 months, the court found that new policy requiring the employee to formally request time off for training was a minor annoyance rather than injury. So you didn't even bother to formally ask for the 3 months off. So you actually had to request it. That might be minorly annoying, but it's not an injury. The court also did not find the constructive discharge, concluding that it resigned on their own after being denied the ability to take time off for the summer classes rather than being actively pushed out. So no, this was not constructive discharge. You're just a whiny little whiner. The court was also unpersuaded that the arguments that this was all pretext. So yeah, if your employer says it's reason X, but it's really reason Y, right? We say we're doing it because of whatever, but we're really doing it for retaliation. The court will look past it. So is this a real reason or is it pretext? Are you just pretending? Well, the court found this is not pretext. No. The alleging that they were denied permission to bring in a metal ice cream scoop and prohibited from bringing plants to the library, there was evidence of pretext. What? So we say this is really retaliation against me as an employee. And the evidence this is really retaliation is I can't bring in a metal ice cream scoop and I can't bring in plants to the library. What does that have to do with anything is beyond me, and also apparently a little bit beyond the court. The court determined that these might be petty slights, not pretext. Yeah, I mean, dude, what does that have to do with literally anything? Is beyond me. This is evidence my employer hated me. I wasn't able to bring plants into the library. What? This is the best you got? The no plants? Uh-huh. How hard is it to prove constructive discharge? Well, it's a question of fact. So, I don't know. Documentation helps. Um, the best thing you can do as an employee when it comes to your employer and issues like this is just documenting things in writing. Um, because the employer will say we didn't know if they can pretend not to know. So I'll answer your question with an example. And I don't know the degree to which this is accurate or not, but or answering your question, but it's the best I can do. Um, let's suppose that you're suffering sexual harassment at work, you know, from a fellow employee or from a manager, whatever the case may be. Okay. So you go to your supervisor or maybe your supervisor, as the case may be, and be like, I'm being harassed sexually at work. All right, here's what's probably going to happen. You're probably going to get a call from HR on the phone. Why are you getting a call? Because they don't want a written trail, right? They don't want a written trail of the thing because then be like, we didn't know, we had no idea, right? And how are you going to prove it? I had a conversation with HR. We have no idea what you're talking about. That isn't what the conversation was, whatever issue, right? So, or your employer tells you to do something. Like, here's another example. Let's suppose your employer tells you to do something and you think, like, this is a problem. Like, I shouldn't be doing this thing. And this would like lead to me being fired if I do this thing, right? So let's suppose your employer tells you to do a thing and you're like, if I do this thing, I'm going to be fired. And your employer's like, do it or you're going to get fired. But if you do it, you will get fired. So what's going to happen, right? Your employer will be like, I never told them to do that. They misunderstood my directions. They misunderstood what I said. Here's the way to solve this problem. Okay. It's actually relatively simple. All right. Anytime you have an oral conversation like this, you do what we call the memo to file, right? It's basically easy. What you do is you create an email. First of all, have the conversation orally, have the conversation orally. So don't, if HR calls you, take the call. If your employer gives you a demand to do a stupid thing, have the conversation. As soon as that conversation is over, as soon as practical, right? It doesn't have to be immediate, but you want it to be as soon as possible. So immediate would be preferable. Later that day would be preferable. Sometime that day would be preferable, right? What you do is you immediately create an email. Emails are great for this purpose. All right. You email whoever you had the conversation with and whoever needs to know. So, like, for example, if you had a conversation with HR, you see, first of all, the email goes to the person at HR. So it goes to the person on the call. Was other people on the call? Was your supervisor on the call? Who was on the call? So first of all, you write the email to everyone who was on the call. That's category one, everyone who was on the call. Category number two is anyone else who needs to know. So, like, for example, if you made the original complaint to your supervisor, you CC them on the email, right? Because that's who you originally brought the issue to, right? And all you do is you give your best recitation in pure fact of what happened, okay? No drama, no emotion, just pure fact. All right. As best as you're able to. Like, You know, and so it can be something like, at approximately 2:30 p.m., I received a phone call from this person. Now you're CCing them, you're writing it to them, but you just put their name in, right? At approximately 2:30 p.m. on this date, I received a phone call from this person. Also present on the call were this person, this person, and this person. During the call was concerning insert issue. During the call, person X said fill in the blank. Person Y said fill in the blank. Person Z said fill in the blank. I said this. Person X said this. I said this. Person Z said this. I said this. And then so you just basically recite it as basically as close as you can with as close to the words they actually used as possible, right? Just give it, this is basically this is a contemporaneous written record is what we're accomplishing. A contemporaneous written record, which is always good for getting around hearsay issues, by the way, as well. It's a contemporaneous written record. Here's what blah, 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 blah. And then you end the email with like, here is my understanding, right? Here's my understanding. To the extent that you were given direction, it's like, here is my understanding. My understanding is that you have directed me to do X, Y, Z. I am going to do this, blah, 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 or it's my understanding that, or if it's like a complaint to them. So if it's like your boss gave you a direction, it's like, my understanding is you want me to do X, Y, Z, blah, 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 blah. And then you finish the email with the line, please let me know as soon as possible if my understanding is not correct. Sincerely yours, blah, blah, blah. Or if they're the one doing something because you raised a complaint, it's my understanding that you are now starting an investigation. It is my understanding that you are now looking into this issue. It is my understanding that, this and that you will follow up with me. Whatever the understanding is, like, again, just factual. What is your actual understanding? And then you finish the line with, you finish it with, if this is not correct, please contact me. Okay? And you send it off again to anyone you have the call with, anyone who is on that call anyone else who needs to know. So all the people are on the call and your supervisor or your supervisor, as the case may be. All right. And then, if you get a respond email, which, you probably won't, if you get a respond email, then great. If you get a respond phone call, which is much more likely, whatever, then you just do it again, right? So you just do it again. If you get HR gives you a call, it's like, hey, what's the point of this email? If the HR says, what's the point of this email? I just want to document my understanding. Make sure everything was clear. It's like, we don't really do that around here. We don't really do written emails. It's like, we don't want you to do that again. Okay. We don't do written emails around here. We want everything to be, you are forbidden from sending another email. Okay. What do? You send an email. Of course you do. Right? You called me at 4:45 p.m. During this call, you said, during this call, person X was on the call from HR, said, we don't really do written emails around here. We don't really do this. We want more stuff. It's during the call you said, I am forbidden from sending other emails about this issue in the future. It is therefore my understanding that I'm not allowed to send emails about this. Per your instruction. If this is correct, please let me know. Sincerely yours, blah, blah, blah. And if you get another call, what do? Another email. And just do it. Just keep sending the emails. And you CC yourself, by the way, as well. CC your own private account or BCC your own private email account so that you have a record of this, just in case you get fired. And then, like, if you get fired or whatever, you have a nice written record of what happened. So that's how you solve all those problems. The memo to file is the best protection known to man. Whatever it is, your employer wants you to do a stupid thing, document. And that wasn't what I told him to do. I didn't tell him to do that. That wasn't my order. Document, 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 man. It saved my ass before, let me tell you what. It has saved my ass before. You know, there was a time there was a time when I wanted to do something at work that I knew was gonna create a problem. I knew I was allowed to do it, but I knew it was gonna create a problem. So what did I do? I did all this in advance, right? I'm like, okay. It's like I went to my employer, I went to my boss's boss in this. I'm like, I'm letting you know in advance. I am going to do this. Here's all the reasons I'm allowed to do this. Here's the policy, here's every policy that applies, here's every rule that applies on this issue. And I am doing this. And I spoke to general counsel about it and I spoke to everyone about it and I document, document, document. And then I went and did the thing and someone complained and I'm like, already got it approved. And I never heard from them ever again. Thus, that brings us to the end of the issue dealing with this person who filed a lawsuit with respect to a public accommodation because they didn't really ask, and what they asked for, they got. And everything else they wanted, they didn't ask for. And also, it wasn't retaliation or constructive termination. So they lost basically because, well, they had this sort of informal relationship with their employer and they wanted to turn things into a more formal way, which, fine. But they only asked for some things and didn't ask for other things. It's like, oh, I thought I'd get this. And no, not so much. Oh, you used to do this, but you didn't ask us. And you wanted this relationship. Oh, you said 8 o'clock start time. Your doctor said anytime between 7:30 and 8:30 would be fine. We gave you something smack dab in the middle. Oh, I thought I could still show up late. No, and all the rest of it. So that all is dumb, and that brings us to the end of that lawsuit, and that for the moment brings us to the end of the discussion of the story. So now I potentially have two different excerpted stories, right? So I have the whole thing about contract law, which could be a story now. The whole thing about contract law. So that rant can be a thing. And then I have this thing about how to solve the thing, which is now a separate story too. So I just generated like two additional stories just by ranting, at least potentially. If you work somewhere that says no email, don't write it down, email and write it down. Email and write it down. Ignore it. Because I guarantee you, they will say that they didn't have that policy. And also, that policy is not in writing. I am sure of it. There is no way, there is no way your employer put the do not email, don't write it down policy in writing. There is no way on this earth. If your employer actually put the don't email, don't write it down policy in writing, then okay, fine. But there's no chance they did that, right? It's more like informal, it's more an oral direction. Ignore it. Ignore it. Write the email. Write the email. If your employer calls you and complains and be like, I told you we don't do emails, email, right? Just pretend like you never heard it. I've never heard that before. I don't remember you ever saying that. We talk about it all the time. I don't remember that. I'm sorry, employer. No problem. I'll just write that in an email about it right now. What are they going to do? Fire you? That'd be fun. If you don't do the email thing, you're setting yourself up for a fall. I'm telling you right now. You are going to absolutely be the fall person 100%. So write the goddamn email. If they tell you not to send emails, if they tell you not to send emails, write the email saying that they told you that. And then ignore it anyway until they actually put it in writing. It's like, I thought this is what you said, but it's my understanding, but it's my understanding that, blah, blah, blah. Just ignore it. Can you be fired for writing emails? Sure. But they're setting you up for a fall. So send the email. Just do it. And if they do fire you for sending the emails, you will have an interesting lawsuit to be sure. Because now you're documenting the fact that your employer doesn't let you send emails or doesn't document things in writing. So you're documenting, a lawyer will love you. A lawyer is going to love you so very much. You escalate it. You escalate to your supervisor. You escalate to their supervisor. Escalate it to general counsel. Escalate. Right? If they fire you, and you go to if they fire you and you go to a lawyer and be like, hey, my employer fired me because I document things in writing and they don't let me document that. And you have emails that you sent and you have all paper trail things you sent, a lawyer is going to love you so very, very much. Right. A lawyer is going to love you very, very much because you've just proven your employer doesn't let employees document things. You have now proven why there is no paper trail as relating to things. A lawyer is going to love you. Because what else is going on in this company? And then when the company's like, we don't know, no one bothered to tell us. They pull out this email chain that proves the company doesn't let them document things. Yeah. Yeah. So if you go to a lawyer and be like, hey, I have all these emails that proves the company doesn't let us put things in writing and doesn't let us email and doesn't and proves all these conversations took place and these are all contemporaneous things, right? Be like, we never said that. We never said that. Right? And we're going to sue the company, right? We're going to sue the company for whatever. It doesn't really matter at this point. We're going to sue the company for anything. It's like, we never said that. Your employee says you did. Hearsay, statement against interest, right? And it's documented. Contemporaneous written statement. It's like, he can't possibly remember that. That's not what we said. Contemporaneous written statement. You never contested it at the time. A lawyer's going to love you so very, very much. You're going to make a lawyer very, very happy somewhere. As you bring down the entire company into a ball of flames. Some lawyer out there is going to start running some ads. Have you ever been discriminated against by this employer? Call me now. We didn't discriminate. That's not our policy. No one ever bothered to tell us. Insert long email chain. Shows that their culture not to document things. Yeah. All right, let's do this story. Oh, you don't document things. You don't put things in writing. Oh, that's interesting. So many governmental agencies are going to want to, this is really interesting. You don't let things be documented. You don't like things in writing. You don't let any evidence be created. So many governmental agencies are going to be all up in your ass. Because what else isn't on the record? The lawyer's going to have so much fun. He's going to call so many state, federal, local agencies, and they're going to be all up in your ass. And then he's going to be all up in your ass with big ass lawsuit and your entire company burns to the ground. It'll be great. Wrongful termination and whistleblower protections probably too. Probably get some whistleblower in there somewhere, I would imagine. Yeah, wrongful termination for sure. We're gonna have fun. Don't worry, we'll figure it out. For today's, yeah, no idea this process even existed. Yeah, well, because most of the time people don't have documentation, you know? So, mostly by the time you go to a lawyer, it's like the thing has already happened and there's not documentation, but documentation is nice. So, yeah. The memo to file is best memo. Yeah. In sports related news, the NCAA, which represents student athletes at colleges, has filed an additional lawsuit that aims to help classify the student athletes as employees for the purposes of federal labor law. This has been a long contested issue when it comes to sports and colleges. Colleges, of course, created sports initially as a pure intramural thing, just an activity that people can do just for fun because people like, to play sports. And so sports basically started as just a student organization. And then, of course, students wanted to play students at other schools in this in sort of a way. And then it became more formalized and more formalized and more formalized until you get to the place where the student athletes are bringing in huge amounts of money and are not getting any benefit from it other than, free tuition and room and board and things, which isn't nothing, but isn't exactly the money that they'd be getting if they were playing for professional sports. So, one of the issues is how do we deal with this? There was a recent change, of course, that said that student athletes do have rights to their own likeness after college. So, when it comes to video games, and for example, they can at least market on that. But how about while they're students? Are they employees? Do they get any federal labor or other benefit protections? So, we are now trying to sue in relation to that. Let's learn a little bit more about how we're trying to change who is and who is not an employee for the purpose of federal law. Let's get started in this. The National Labor Relations Board is hearing a case dealing with student athletes that seeks to change their status as employees. And this precedent could also help other people beyond college athletes, depending on the nature of it, because it could also stretch into gig economy drivers and other workers who are currently misclassified as independent contractors. So, this issue as to who is an employee and who is a contractor is obviously very complex. And there is a lot of different tests on this depending on which agency is resolving this issue, and also a matter of state law as well. The entire case about who is and who is not an employee often boils down into a multi-factor test, and sometimes it's like a 13-factor test because it's really complicated as to who an employee is and who not. Among other factors that might indicate if a person is an employee or an independent contractor would be factors such as, is a person able to set their own hours? Do they use their own tools or do they use the employer's tools? Where's their place of work? Do they work at the employer's place or do they work wherever they want? Are they able to work for other companies? Are they able to set their own conditions of employment? Are they able to set rules for themselves? So these are some of the many, many factors that apply to this. And obviously, how college athletes and how independent drivers for such things as Uber work into this is obviously a much contested issue, as you would expect. The recent complaint against the National College Athletic Association, Pac 12 Conference, and the University of Southern California claims that they employ football and basketball players who are illegally misclassified as non employee student athletes. So we are trying to say that these student athletes are actually employees rather than students. If they won the case, it would require NLRB to rule the act that misclassifies the workers violates the National Labor Relations Act, a legal theory that, of course, has been rejected in the past as well, but an issue of increasing interest in this domain. The case sets up a chance for two precedential holdings, one relating to college athletes, the other for misclassification being a per se violation of the National Labor Relations Act that appear in a single case, which is a rare occurrence. So this would potentially not only solve the immediate issue, but also say that misclassification is in and of itself a violation of law. So would allow people to more easily change their classification status because it would be an unfair labor practice as a matter of law, which it isn't right now. Right now, it's just like which category are you in, but this would potentially change to say that the act of misclassifying is in and of itself a act of aggression on law. Only in a previous incident in 1969 with the United States Supreme Court, there affirmed the board power to order an employer to recognize and bargain with a union in absence of an election when labor law violations make a fair vote impossible. So again, dealing with this issue, federal law does protect union and union rights. One of the things that might prohibit a union from forming is the employer acting in a way that inhibits the union from forming. And so there is precedent for the idea that you can force an employer to recognize a union even if there was no vote, to create the union if the employer itself is prohibiting the vote from occurring. So there is some precedent on that issue as well. While the rule is known for allowing these orders, it also set an important precedent on the distinction between a lawful prediction and an unlawful course of threat. So yeah, this gets really, really complicated, really, really fast, as you would expect. Employers do have free speech rights, including the free speech rights to say we oppose unions. So merely the employer saying we don't like unions, unions are bad, here's all the reasons you shouldn't vote for a union, that in and of itself is not illegal. It's only illegal if it becomes coercive. And God knows that a lot of employers try to tread that line real close. So in terms of where they are and stuff, it can get really, really complicated. But employers are pretty good about towing this line. Perhaps too good, but that's where the law is, right? So there's a difference between merely saying, we don't like unions and we'll fire you if you join a union or create a union. So how employers play that line is obviously really interesting. The misclassification complaint against the NCAA is not the only major pending case on this issue, as you would expect. There's lots of issues that are related to this. The General Counsel's office is also litigating a case relating to a construction company that argues for resurrection of a legal doctrine allowing unions to represent workers without an election, as well as having compulsory anti-union gatherings declared illegal. So one of the things that employers can currently do is gather everyone in a room and be like, geez, aren't unions bad? We don't like unions. They're really bad. We don't like unions. Unions are a bad thing, and you should not like unions. And we don't like unions, and we hope that you will not recognize the wisdom that unions are bad. And they're allowed to do that. So this is a very fine line between, we don't like unions and nice employment you have here would be a shame if anything happened to it. So that line between legal expression and blackmail, well, some employers are towing that line really, really closely. There had been a case that challenged a decision and argued for making misclassification a standalone labor violation. But that particular case, which stemmed from union charges relating to trucking, settled before the ALJ could do it. So again, is misclassification itself a standalone violation? Not right now, but someone is trying to change that, but a prior precedent settled before the issue was resolved. The joint case against the NCAA, Pac-12, and the University of Southern California will probably take a long time. Yeah, that's for sure. The closest comparison is arguably the joint employer case litigated McDonald's. The case began in 2014, didn't end until 2022, when federal employee court rejected a union challenge to settlement agreement that cleared the company of any joint liability. So yeah, these things can take a long time because they're factually complex, they're legally complex, and the line is a little bit blurry, and God knows employers play with it. That's enough of that. Thus, that brings us to the end of the case dealing with reclassification efforts as it relates to the NCAA. which could potentially impact gig economy businesses and other businesses, depending on the nature of the ruling. So we're going about this two different ways. First, we're saying that we have been misclassified and they are employees, which is an issue unto itself. But the bigger issue is that misclassification is not, as of now, a violation of labor law unto itself. So it might be wrong, it might be the wrong status, but the fact that we misclassified you is not in of itself a labor violation. So the only remedy is to change your status, right? Say, oh, you really are independent contractors, oh, or you really are employees, as the case may be. But there's no penalty for getting it wrong, which obviously might incentivize some businesses to, get it wrong because there's no penalty, and they gain the benefit of the benefits of the status while it's in play. So we're trying to change their status, which is an issue unto itself, and also trying to change it into a fundamental per se violation. So that would be a penalty for misclassification. So this issue will be long percolating, I am sure. I don't know how this will resolve in the case of the NCAA, to be honest. I don't know that that will ultimately get anywhere on that particular issue because the nature of what we're talking about, but they're going to try. And that, for the moment, brings us to the end of discussion of this case. Am I playing Zelda? Well, I have some work to do, and I probably need sleep at some point. And God, it's already 12. My first story is posting at 1. Oh my God. All right. Push the button. Thank you. Didn't the Supreme Court rule that employers can sue unions for damages created by the union? Yes. Yeah. I'm not sure how that would have anything to do with the issues we just described. That's not, there's no relevance between it. But yes, the Supreme Court ruled that employers can sue unions for damages created by the union. Yeah. In Florida Man news, a man entered a home in Florida while the family was trying to eat dinner, claiming that he was a ghost. You might remember recently we covered a case in which Florida man attempted to enter a home to escape a ghost. So maybe this was the ghost. He was trying to escape. Maybe that is further defense to the other guy. This was the ghost I was trying to escape because he's claiming he is a ghost. So maybe that's it. Maybe our defense for that entry of the home to escape ghost is looking better and better. But let's discuss this case. The guy who says he is a ghost and enter the home. Why did he enter the home if he's a ghost? Let's learn more about this. The Fort My Thank you for the gift membership, Ellen. A Fort Myers family had some unexpected company for dinner on Thursday night. The McClaslands were sitting down for supper when all of a sudden a random man came barging in the front door. Well, that would definitely get my attention. He had only on a bathing suit, no shoes or anything else. Ghost likes to swim. I mean, I understand. Swimming is good. Maybe that's how the ghost died. Well, you don't know his life. Maybe he died in a drowning accident while he was swimming. And now he's doomed to wear swim trunks for all of eternity. Such discrimination against ghosts going on here. It's unreal, people. He was at the table when his two teenage daughters, when he heard what he thought was knocking on the door. As I walked out of the area we were eating dinner at, there was an individual in the living room or my front door area proceeding to advance into my house. He was in the house. He's got some unsettled business in this earthly plane. Can't you be more compassionate and help him gain detachment from this earthly realm so he can rest in peace? Why won't you help Ghost Florida Man? He needs your help. Surprised at what he's saying, the McClaslin said the encounter became even stranger once the man opened his mouth. He started to tell me he was a ghost. I shouldn't be able to see him. He was shocked that I could see him. He thought that he was walking around that nobody could see him. Man, this sounds a lot like the movie Ghost, where the titular character wouldn't be able to be seen by most people except for the one medium who actually could see him and actually gain the sight. And then Whoopi Goldberg over here helped him, end his journey. And the fact that you can see him, man, that must be one hell of a relief to Ghost Friend. And over here, you can't help Ghost Friend. You are the only person that can help him. How cold is your heart, man? How cold is your heart? Brian, barely able to see what he was seeing, tried to get the man out the front door he came through. I could tell his behavior is not normal. Well, maybe it's normal for a ghost. Do you know a lot about ghosts? Why are you judging him based on your observation of people? He's a ghost. It's such a bigoted approach, trying to apply your standard of living to the recently deceased. Who knows what the person might do if they had a chance to think? Well, I don't know if ghosts think or not. Maybe they act more on instinct. Again, who are you to judge? After causing the scene inside, this guy, who claims his name is Kevin, came running outside to where the crew was cutting down a tree. He hopped in one of their trucks and locked himself inside. He says he doesn't have a home, and he's going to make the truck his home. Okay. How does adverse possession work with ghosts? I don't know. He has commandeered the truck and wants to turn it into his home. Is that grand theft? Is that squatting? Okay. At this point, the man barged inside the home, thinking he's a ghost, is now going to barricade inside the truck belonging to the tree trimmers. I think this is all wild, McClaslin said. Well, not sure why he thought the tree trimmer truck and this home was the way to go to solve his problems. Maybe it was a bathing suit accident relating to tree trimmers. Okay, so maybe what happened is he was swimming in a pool, and some nearby people were trimming a tree, and they did it negligently, and the tree they trimmed fell into the pool, hitting him on the head, causing him to drown. And he needs to unite all these interests in order to solve his own mysteries of his death and get at peace. So seizing the truck of the tree trimmers makes more sense because it relates to his swimming-related drowning accident. I understand. The fact that these people can't understand it is beyond me. I think it's all wild, McClaslin said. It took some coaxing, but the tree trimmers were able to get the man out of the truck where he ran away, still wearing nothing but the bathing suit. He was definitely something. Yeah, he's a ghost. McClaslin called the sheriff's office and filed a report. He now wants deputies to find the man, but not press charges. So perhaps a little bit more understanding. Hopefully we can find this individual and get them the help they need. Well, that is a little bit compassionate, to the ghost friend. So, we don't necessarily want to do something, but we're calling the proper authorities, which apparently is not Ghostbusters. Apparently it's the sheriff's office. Has the sheriff's office opened up a ghost busting facility? Are they able to properly treat the ghosts? Do they merely get them together with their proton packs and put them into ghost traps and lock them away? Or do they help them with the therapy? How does that work? Do we have rehabilitation for the ghosts? Do we get them the treatment they need? How does that work in Florida? Unclear. Thus, that brings us to the end of a person's former life as they are now a ghost in Florida. And much confusion is abounding here, but at least the homeowners don't want to press charges against the ghost and want to find the ghost so that they can get him help. Also, possibly indict him as it relates to chasing that other Florida man who ran into a home to escape the ghost. So I'm not sure how any of that works and why a bathing suit and all the rest of it is involved, but It could be relating to the tree trunk that hit their head and caused them to drown from the tree trimmers who were negligent on a nearby property and on all the rest of it. And just trying to get that last minute of peace. Hopefully, everything will come to a nice resolution over here in Florida. And that, for the moment, brings us to the end of discussion of this story. Thus ends the stream. Thus ends the stream. We can push the button for the end of stream just to push ourselves into the habit. Thus ends the stream. Well, my friends, my throat apparently is still shot to all hell. I'm tired. I'm grumpy. On a scale of 1 to 10, how good was this stream? Was it okay? Did I do okay? Was I a good uncivil? Was I a good uncivil today? Oh, yes, you sent me DMs with super chats. That's right. I forgot that you do that because that's how tired I am right now. Mortessa gave me 5 gift memberships. Sandra gave me 5 gift memberships. Z Zelter gave me a $5 super chat. Brian Gibson gave me 10 gift memberships. And Alan Parker, Hero, gives 20 gift memberships. 7, I'll take 7. Start at 4 and finish at 9. Yeah, that sounds about right. That sounds about right. At least an 8. Yeah, I think start at 4, end at 9 is not. Yeah, it was not my best work. I think that's fair. Oh, Lord. All right, I got to schedule posts today for 4 and 7. So I got to do that, then maybe take a nap. And then I have improv tonight, too. We did a showcase yesterday, but today is my regular class day because it's Monday. $2 from Charlie in memory of Florida. Yes, I have a CPAP. I use a CPAP every night. If I don't use a CPAP, I have a very bad time. And also, hypothetically, I'm supposed to go to the gym today because I switched my schedule into a different lifting schedule. So I'm also supposed to go to the gym today. Some tea sounds good. Oh, I have some tea. All right, I have work to do. I have work to do. I've been on civil law. And then I got to edit this video at some point too. Got to edit this video. I still got to curate it. It's gonna be a day. I've been on civil law. Until later, my friends. I hope all is well. Cheers, my friends, and goodbye.